Welcome to the Point Podcast. I'm your host, Rinn, and I'm here with Steve Oakley, and who is the president of Steve Oakley Law Group and located in Burbank. Steve is a firm's principal attorney and received his law degree from UCLA School of Law in 1995 and is admitted to practice before all California courts and in the U.S. District Court of the Central District for California. The Oakley Law Group focuses exclusively on estate planning and wealth strategies. He is a veteran of the United States Army and spends his free time dabbling in aviation and supporting several nonprofit organizations, including the UCLA Alumni Scholarship, the Shriners Hospital for Children, and many others. Steve is happily married, has 5 children, and lives in Burbank. So, Steve, tell us why living trust is so vitally important today.
Well, good morning, Louis, and everyone. I think about that every day, but not necessarily in an organized fashion. So, what most people don't realize is that planning can be extremely powerful. Most people only think of a living trust to avoid probate, and are really clueless about the power of a good, robust trust. So here are some of the benefits. There are really too many to go into any kind of detail today. Most would probably be its own podcast, but here's just kind of a list. Of course, the obvious is to avoid probate, avoid that time, that expense, and that additional stress on your loved ones. A good trust provides for responsible transfer of wealth to the next generation. It can help you eliminate estate taxes or minimize them, its impact. It's good for passing on your values to your children, incentivizing your children. Trust can provide asset protection, divorce protection, remarriage protection. Also protects you against incapacity. Doesn't stop you from being incapacitated, but it can protect you and help control you, keep you in control of your wishes. There's also potential protection from future nursing home costs. You can provide for blended families, provide guardians for your children. It also promotes family harmony and avoids fights, or at least minimizes the risk of fights. You can provide for disabled beneficiaries in the proper way so you don't upset their government benefits. You can address addiction and spendthrift concerns, provide for irresponsible kids. I have 5 of them. Most of them are responsible, but a couple are, we're working on that.
You may be in trouble for that.
Right. You can teach your children financial responsibility. And it's also good for transition of business or professional practice so that there's continuity of management. So really, a good living trust really addresses everyday issues and concerns that most families have. So here's where people kind of really run into trouble with trust. Is people think all trusts are created equal and kind of think of them as a commodity, meaning a lot of people are looking for the cheapest trust. But when you're thinking about estate planning, you really have to ask yourself, if you're going skydiving, would you look for the parachute guy that sells and packs the parachute for the lowest price? Probably not. Okay. Okay.
My next question to you, as you know that I work with a lot of realtors, and some of these questions perhaps would be very, very appropriate for realtors. So let me ask you something. What would you suggest for realtors? Well, we have realtors who representing buyers and we have realtors who are representing sellers. But let's talk about those realtors who are representing buyers first.
Okay. So one of the biggest things we run into are for realtors is vesting of title in properties. So there's really a best way to vest title on purchases of new properties. The living trust is the absolutely best way. But if people don't have a living trust, then taking title, well, in the old days, when a buyer asked, how should I vest title? Kind of the standard answer was joint tenants. That's what married people do. Okay, those days are really gone. The best way is to have them take it as community property with right of survivorship, because when you do it that way, it avoids probate, and also there's a huge tax benefit for the surviving spouse when the first spouse passes away. Okay. But when you have it as community property, it does not protect against issues like incapacity. I think some other things I'll touch on with this is, since I mentioned joint tenancy, let me tell you why it's bad. Okay. A lot of people use joint tenancy because they say, well, it avoids probate, right? If I die, it goes to the next person. And that's true. Okay. But there's a lot of issues with that. So joint tenancy is really like last man standing. Okay. So for instance, if your home is in joint tenancy and one spouse becomes incapacitated, they have a stroke, accident, develop Alzheimer's, something like that. Well, the other spouse, the well spouse, can't sell the house, can't refinance it, take a reverse mortgage, or do anything because that other spouse is incapacitated but not dead. And joint tenancy only works when somebody dies. The well spouse can't access many other financial accounts like IRAs or Social Security, things like that. And again, once the last tenant dies, it goes to probate. Another big problem with joint tenants, because I see a lot in this area where single parents will put their adult children on title with them. And that's really the last thing you want to do. When you put your child on title, they become part owner, and now your property is subject to their debts, their marital issues, their bad attitudes. Just a really quick story. My wife's cousin here in Burbank, his mom was in her 90s. She was a widow, owned a home that she bought in the early 1960s. Obviously, she's going to leave it to her one son. And, he wasn't the sharpest tool in the shed. So she put his name on as joint tenants. Well, being that he's not a rocket scientist, he was driving along Buena Vista Boulevard, made a left-hand turn at the light, and had a blackout. And when he came to, he found out he had hit a pedestrian, and that person lost a leg. That person sued him for $20 million. And because his mom had added his name to her property, her house is in jeopardy. She could have lost her house because he was partial owner of it. Fortunately, it got resolved, but can you imagine the stress it put on this 90-something-year-old lady? And it was all avoidable, but it happened because she just didn't know any better. Okay? So there's two types of community property vesting for titles. There's community property with right of survivorship, and there's also just straight community property. So really kind of what's the difference? Well, community property with right of survivorship means that when one spouse dies, it automatically goes to the surviving spouse. The other way, when it's just straight community property, there may still be a probate when that first spouse dies. Okay, but they will receive these tax benefits I spoke of earlier. I'm sorry. Once that probate is over. Let's talk a little bit about living trust in relation to property. I said that's the best way to hold title. And it's the best way because in the event that one of the spouses, becomes incapacitated, the surviving spouse or the well spouse or the children, if they're a successor trustee, they can handle everything. Okay. In case there's a disability or a death, it eliminates conservatorships. It eliminates that lack of access to all the financial accounts, Social Security, IRAs, things like that. And it avoids probate while still giving the great tax benefit to the surviving spouse on real estate and also on investments as well. Okay. One of the other things, I know that a lot of realtors themselves, and they have clients who have investment properties, rental properties. So a good vehicle for that is an LLC, a limited liability company. And that's great for asset protection on rentals. Because what that does is it contains the liability related to that property and protects your personal assets, your home, your life savings, all these other things in the event of a lawsuit resulting from that property. So if you're familiar with the snow globe, which we all are, you shake it and the little flakes of snow, it's kind of like putting your property in a snow globe. So nothing gets out. That liability is encapsulated in that just related to that property and doesn't flow out to your personal assets. The problems a lot of people have with forming LLCs is one that they can be a little bit expensive in California. There's a minimum $800 a year, what I call privilege tax, just for having an LLC. And ideally, each property should be in its own LLC. So a lot of people don't want LLCs. So the next best line of defense for investors, if they don't have an LLC, is to have a good umbrella insurance policy. And that's really critical. And I advise my clients of that all the time. So why is this important to realtors, knowing all these things? Well, really, having this knowledge and being able to advise your clients without practicing law, without a license, obviously, it makes the realtor stand out from the rest of the crowd. You become more of their trusted advisor. It helps you establish a foundation for an ongoing relationship, which is what you want with your client. So you kind of become your client's go-to realtor. And just like I said about trust, all realtors are not the same. They're not a commodity. Everybody's a little bit unique.
So what you recommend for realtors, especially those who are dealing with buyers or with sellers, to ask some questions. Ask questions whether they have a living trust or how they propose or what they think how they should take title. And if they have any question, consult somebody like you who is an expert on it, instead of try to be an attorney or a CPA. Just be a realtor, but ask the right questions. Okay, Stephen, my next question is about the realtors who listings. As you know, listing is gold today, especially the way the market goes.
Sure.
A lot of the realtors just wants to list. So what would be your advice to the listing realtors?
Okay, great. And I just want to say, you mentioned a good thing about getting advice from the wrong people. Usually the best intentioned people, which are family and friends, give the worst legal advice. Okay. Right?
Typical.
Yes. Okay. So for realtors representing sellers, I have some tips or some advice that'll help you. So everything we talked about representing buyers still applies. Okay. Especially since many sellers are also current or future buyers, right? Mm-hmm. So one of the most important things when you get a new listing is you want to check the vesting of the title as soon as you acquire that listing. You want to be sure that the listing seller is actually on title or has the authority to sell the property via a power of attorney or their trustee on a trust. So this is probably the single most important piece of advice I can give, because I've seen these problems done dozens, if not hundreds of times in my practice. They could have been easily avoided. And, one of the things we're setting up in our practice is we're going to post it on our website where a realtor will be able to come on there and download a quick down and dirty kind of power of attorney if they need it for a client that they're in a transaction with. So here's a big thing. So if a seller is a trustee on a property, but the property is not currently vested in the trust, there are a lot of problems. We'll talk about some of those problems and, some of the solutions as well. Obviously, talking about just the problems wouldn't help without some solutions, right? Okay. So often, as a realtor, you'll get a listing from a seller who states that the property is in a living trust and that they're the successor trustee and the original owner has passed away, right? So many times the realtor takes the listing, does a lot of work to acquire a buyer. They strike a deal, goes into escrow, and title or escrow informs the realtor that, hey, the property is still vested in the deceased person's name, the deceased owner's name. And this is obviously a huge problem because obviously before that seller can sell and the realtor can make his commission, it must go through some sort of a probate or court petition process. That process can take several months or even years to get authority and permission from the court for that person to actually sell the property. So obviously it's bad for the seller, it's bad for the realtor, it's bad for the buyer. Oftentimes in these cases, the buyer's not going to stick around for months or years, waiting for, permission to sell the property. And this usually happens because, where people have a trust and it's not titled in the trust, usually for one of two reasons. One, they had it in the trust, but they refinanced. And a lot of mortgage companies, not so much nowadays as they used to, will require the borrower to take the property out of their trust during the refi process, but they don't put it back in the trust. And a lot of borrowers don't even realize it's been taken out of the trust. Okay, so that's a big problem. The second reason this normally happens is because people don't fund their trust, meaning they set up a living trust, and a trust is like a bucket, and a bucket's a great tool if you put stuff in it, right? If you don't put anything in it, it's just kind of ugly and kind of a weight on your arm, right?
Right.
So they haven't taken that extra step, and they use an attorney. I blame the attorney for this. They haven't taken the step to actually title that property into the trust. So how do you fix these kind of problems? Well, if you find yourself in that situation, the best case scenario is to do what's called a Hegstad Partition. Okay, and this works really, really well if all the beneficiaries involved in that trust are cooperative. Okay, when you do a Hegstad Partition, in LA County can typically take several months to do it. Okay, but we have a method in our firm that we can usually get that done in about a month or so, which is great because you can transact that sale, close that sale. But they can be expensive, and that's easily avoidable to avoid that whole situation. If you immediately search, you have a title search done when you get a listing. Talk to your title rep. And then if there is a problem, you can start those processes right away in the very beginning of the transaction versus when you have a buyer. Very
important.
Yeah. Okay. So now there's some, kind of the most common listing situations we see. We see most properties are in joint tenancy, or they're community property if it's a couple, or a single seller that's a widower or something like that. And this is something that happens not as often as the previous situation, but it does happen. We've seen this many times. Is a realtor will obtain a listing, maybe from an elderly couple or a single person, and the property is in their name. They don't have a trust, okay, which is fine. Maybe it's joint tenants or by community property. And there's usually one of two scenarios that arise. During the sales process or the listing process, throughout the transaction, one of the spouses becomes incapacitated. Mm-hmm. They have an accident, a stroke, Alzheimer's, something. I mean, we don't know. We've seen it all. And now they're no longer legally able to sign documents to finish the transaction. And there's no immediate solution when that happens, and a conservatorship is required. And conservatorships take a long time. They're very expensive, very cumbersome. And of course, again, it kills the sale. Okay. The second situation we see is that the couple is fine, but again, one spouse becomes very ill or incapacitated, and again, a conservatorship is required. So one of the solutions, and that's especially if you have a single person, even if they're young, they can become ill or incapacitated during that sales process. So a solution I like to see, and really no realtors that I know of do this, they really should. As soon as you get a listing, whether it's from a married couple or a single person, you should encourage them to sign a power of attorney, giving the other spouse the act on their behalf in case something happens to one. Or if it's a single person, definitely give power of attorney to your child or your sibling or something like that, so that if something does arise during that sales transaction, that person can step in and complete that transaction on your behalf. And it doesn't have to be a really complicated power of attorney. It can be very specific, So again, that's something that I recommend as a kind of a best practice, to have the seller sign a power of attorney for someone in case of that disability, during the sale.
And Stephen, exactly the same thing happened to me a year ago or about 2 years ago, that the client's wife was incapacitated. But the problem was that they signed a power of attorney maybe 5, 7, 8 years ago. and now she couldn't sign a new power of attorney.
Right.
Excellent point.
Right. And one of the things to remember about power of attorneys and really trust in general, we like to think of it as a one-time expense that's once and done forever. But especially with a power of attorney, institutions are very hesitant to accept a power of attorney that's 10 years old, 5 years old. They say it's stale. And by law, they really don't have to accept a power of attorney. It's a little tougher for them to reject one if it was created by an attorney. There's actually a probate code section that can sanction them if they do that. But it's very important to keep, your estate planning documents up to date. And I'll touch on that a little bit more if we have time. Okay.
Steve, what other services do you provide? If anybody calls or want to get in touch with you, can I post your contact number and email address? And if you can explain what other services do you provide so people
sure
contact you.
Okay, I'd be happy to. And of course, to all your listeners, I'm fine with you posting my contact information. There's myself here. We have a large support staff. We have a total of four attorneys, and they're all very, very good. With our firm, we're not what we would call a full service firm, which means we don't do everything. If you have a slip and fall or bankruptcy or you want to divorce your spouse, unfortunately, we don't do that. We can refer you to someone who can help you with those issues, because we want to be your go-to trusted advisor. But our focus is strictly on estate planning,
right.
helping families. And what I found through experience is that as an attorney, there's a lot of nuances in every area of the law. And if you try to do too many things, typically you end up not doing any of them really, really well. So me personally, I'm not smart enough to be an expert in a lot of different areas, so I have to focus. One of the resources we like to provide to realtors and other professionals is that with us, you have someone you can call. If you have a client with a question, or you have a question about your own situation, you can always feel free to call us. We can have a 10 or 15-minute call. There's no cost for that. There's no obligation. There's no expectation that if you have one of your clients call us and ask us questions, that they're going to become a client. We know by helping, people with these issues, that it kind of comes back to us, in the future. So we're happy to do that because you encounter a lot of situations, and we're always happy to talk to people. We're a relationship type of practice. So, if it's any estate planning issue, we should be able to help advise you on, or at least point you in the right direction. Estate planning, is a pretty large area. There's some things we personally don't do. We don't do conservatorships, things like that. And simply because, they're cumbersome and I don't like them, but I can always refer you to someone who does a lot of those. Okay.
Okay, Steve. But listen, it was very, very helpful. I really appreciate your time. And certainly, I'm sure a lot of people will be interested maybe to talk to you, but at least interested to learn from you from this podcast. So if anybody wants to contact you, they can call you at 818-937-2335, correct?
Right.
Or
correct.
It can email you, steve@oakleylawgroup.com.
That's correct, Louis. That's correct. And if we have a few more minutes, there's a couple other things I'd like to touch on. If we don't, that's fine as well.
We have a couple of more.
Okay. So a lot of people think, gosh, estate planning is really boring. You talk about taxes, you talk about death, but I really enjoy it because there's always something going on. It's very closely tied to politics, so it's kind of like the Wild West. So one of the things I want to mention that don't affect maybe a ton of people, but a large enough segment, enough of your families and your clients that it may be of interest. So I want to talk a little bit about estate tax updates that are on the horizon.
Great.
Possible solutions and strategies with those. So as we all know, the Democrats are controlling both houses of Congress right now, and there's many new tax bills on the horizon that are floating in Congress right now, and something is likely to pass this year. If you think about it, we have a pandemic to pay for, all this money we've printed. They say money doesn't grow on trees, comes off a printer, but somebody has to pay for this. The best way for the government to recoup that is through, of course, taxes. So probably the biggest concern for a lot of people is the reduction in the estate tax exemption. So an estate tax is a tax on what you own when you die. It's money you've already paid taxes on, but if the government thinks you have too much money, they're going to tax it again. So it's kind of a second bite at the apple. So under the Trump administration, that exemption was $11.5 million per person for a married couple, which meant unless you had more than $11.5 million, you didn't have to pay estate taxes. Okay, but a lot of the laws that have been introduced are going to reduce this down from $11.5 million to maybe as low as $3.5 million. Okay, still a lot of people won't affect, but it will affect a lot more people who own properties. So estate taxes average out about 40%. So if you're over that exemption, everything over that, including life insurance death benefit, is going to be taxed at 40% rate. That's huge. Okay, and that can be disastrous for many families, especially if they hold a lot of their wealth in real estate. So, and what a lot of people don't realize, as I mentioned, life insurance death benefits, you're always tax-free. It's income tax-free, but it's not estate tax-free. It's definitely counted as part of your estate when you die for estate tax purposes.
Excellent.
So there are, yes. Yeah. So there are a few solutions I'll mention here. One would be gifting assets to your children or grandchildren, setting up a life insurance trust, and there's another trust right now that's been around a long time. It's become very popular. It's called a SLAT, S-L-A-T, which stands for Spousal Lifetime Access Trust. And for people who are over that potential estate tax exemption, it can virtually eliminate those estate taxes.
Right.
The other thing I just wanted to touch on is because we have an aging population, you look at Lewis, you look at myself. Okay.
Yeah.
Most people before they pass away, are going to end up spending time in a nursing home. The average rate for a private nursing home room right now is about $12,000 a month. It's not covered by Medicare, and we see a lot of families going bankrupt, a lot of families losing everything they've worked for that they had planned to leave to their children because of these nursing home costs. Most living trusts don't have any triggers to address those type of issues. One of the things we've started doing in our trust is we include those kind of triggers so that if that situation does arise in the future, it allows you to do that planning necessary to reduce or eliminate those costs and preserve, those family financial legacy. And the last thing I'll touch on is, a lot of people have a trust, but a lot of trusts don't work. And so why do trusts typically fail? And there's really a few reasons. One, as I mentioned earlier, poor planning. People go to LegalZoom. I tend to call it legal doom because that's often the end result. They may go to a jack of all trades attorneys, someone who doesn't really specialize in estate planning, or they may get a will. If you have only a will, you're definitely going to go to probate. And again, I gave that parachute example. If you want to save money, click coupons for the store. You don't want to buy the cheapest parachute out there. There are attorneys out there who charge $495 for a trust, and it's not the same. If you think of a Geo car and a Lexus, they're both cars. They have tires, they have wheels, they have engines, steering wheels. But, you're going to feel more comfortable in one if you're driving on that road up to Big Bear that has no guardrails and a 5,000-foot drop-off than you are on the other. Okay, so they are different. Another reason they trusts fail, is because they don't get updated. Having a trust is like owning a car. You have to look at it. The laws change, your family situation changes, your assets change, so it has to be maintained. We meet with our clients at least every 3 years to review their trust. We keep them abreast of changes in the law because you don't want to have that false sense of security. You want to make sure this is going to work when that time comes. And the last reason, which I touched on earlier, is trusts are not properly funded. People haven't put their assets in that bucket. We have a client right now. Well, he's a client because he's in probate who had a trust, has millions of dollars worth of assets, did not put them in his trust, passed away recently. His family has come to us, and we have to probate that. That probate is going to take probably a year and a half, best case scenario, maybe up to 3 years. And the probate expenses are probably going to be about $150,000, right? And he had a trust, but there was nothing in that bucket, so it's that false sense of security. So what you really want, if you're thinking about estate planning, is you want something that's comprehensive, something that's tight, something rock solid, and ironclad, and that specifically addresses your family's needs in your unique situation, because your family is not just like your neighbor's family.
That's right.
Anyway, that's I think that's all I have on that, Louis, unless you have some other questions you'd like to ask me.
Yeah, I really like, you really covered it very, very well. But if I can repeat, the most important thing is if you have a trust, if you don't have a trust, to have a trust. But if you have a trust, have it renewed or revisited by your attorney at least every couple of years, every year, because there are always changes, as you say, in the tax laws, in the everything. And so you need an expert advice on what to do and how to do it. And the best way to do it is to see Steve Oakley.
Okay. Yeah, and absolutely. You know, I've seen people come in where the parents have died and the children come in. It's a trust that's 15, 20 years old. Looks like it was created on stone tablets, right? And it doesn't work at all. And it's a shock to a family and just a lot of misery. So, Louis, you're absolutely right. I appreciate and thank you for spending the time to talk to me today. And hopefully, your audience got some good information, at least a little bit of education. If they have any follow-up questions, they can feel free to shoot me an email or give us a call.
Thank you very much, Steve. It was great information, and I'm sure a lot of people will benefit from it. Have a great day.
Okay. Great. Thank you, Louis. Bye-bye.
Thank you.